Any person interested, central government also can file the case, especially the revocation we are talking. Okay, so I mean revocation is there, that patent right is like a revocation related matter is there. Any person interested, central government and defendant making the counter claim for the revocation in a suit for the infringement. Okay, so all these three are important, that important in a sense they have a right to file the case of a revocation, that is like that. And who can revoke? High Court on a counter claim in a suit for infringement, right? So High Court have authority, district court have not authority of revocation, High Court have authority for the revocation, and these are the three, that is any person interested, central government, and then the defendant making the counter claim. Okay, so that is like a revocation. Now further, when we go into the that 104A, which is related to burden of proof in case of suit concerning with infringement. So first we understood jurisdiction, then we have understood that who can file the case in case of a revocation. Okay, now we will see that a burden of proof. Now see here, in any suit for infringement of a patent, where the subject matter of patent is a process for obtaining a product, the court may direct the defendant to prove that the process used by him to obtain that product identical to the product of the patented process is different from the patented process. Further, what it says, if the subject matter of a patent is a process for obtaining a new product, or there is a substantial likelihood that the identical product is made by the process, and the patentee or a person, what we will do just before going into the details, we will share this in the reading material. This especially chapter 18. We will share into the that, because everything we cannot put it here. So what we will do, we will put that reading material. So whenever this lecture or this session you will go into details, please keep that reading material in front of you. Especially I will suggest to keep hard copy so that you can keep see the video, check that in the hard copy so that you can easily understand that. Okay, so I have just written a starting details of that section here. You can just see, but the details further are in that reading material. Okay, so you just take a print out of that. So what it says, that if the subject matter of the patent is a process for obtaining a new product, or there is a substantial likelihood that the identical product is made by the process, and the patentee or a person deriving title or interest in the patent from him has been unable through reasonable efforts to determine the process actually used, provided that the patentee or a person deriving title or interest in the patent from him first proves that the product is identical to the product directly obtained by the patented process. Further, in considering whether a party has discharged the burden imposed upon him by subsection 1, the court shall not require him to disclose any manufacturing or a commercial secrets if it appears to be the court that it would be unreasonable to do so.